In Article 83.1 of the TFEU, there's a reference to the notion of an EU crime. Could you help us understand what this means? What is an EU crime, and what is the significance now that violating EU sanctions has been elevated to that status?
You are listening to This Month in EU Sanctions, your go-to podcasts for the latest updates, insights, and in-depth analysis of the EU's evolving sanctions and trade compliance landscape. I am your host, Jan Dunin-Wasowicz. In each episode, this podcast examines some of the latest developments shaping EU sanctions law and policy, combining legal and institutional analysis with a practical perspective on implementation, compliance, and enforcement. Subscribe to the LinkedIn newsletter, This Month in EU Sanctions, to receive a selection of monthly updates, including topics discussed on this podcast. The summer of 2025 has been exceptionally active in the EU sanctions space, reflecting a flurry of diplomatic activity and the gravity of the foreign policy and security issues that the EU needed to grapple with. Having renewed its sanctions against Russia in June 2025 until the end of January 2026, on July 18, 2025, the EU adopted its 18th sanctions package, one of the toughest rounds adopted to date. The 18th package included, among other measures, sanctions against 14 individuals and 41 entities, including in third countries, lowering the price cap for crude oil from $60 to $47.6 per barrel, and a new price adjustment mechanism, an import ban on refined petroleum products made from Russian crude oil coming from third countries, a port access ban on 105 further vessels in the Russian shadow fleet, a transaction ban on Nord Stream 1 and 2, upgrading the ban on providing SWIFT services to Russian banks to a full transaction ban, and applying this new ban to an additional 22 Russian banks. A ban on carrying out any transaction with the Russian Direct Investment Fund, export restrictions on dual-use goods and technologies for 26 new entities, some of which located in third countries, additional export bans and measures related to investment treaty arbitration. In mid-August, discussions were already underway concerning a potential 19th package that could be adopted in the fall, with EU leaders declaring on August 16th that, as long as the killing in Ukraine continues, we stand ready to uphold the pressure on Russia. We will continue to strengthen sanctions and wider economic measures to put pressure on Russia's war economy until there is a just and lasting peace. Meanwhile, also in August, the E3 issued a joint statement signaling the possible reimposition, or snapback, of sanctions in Iran in response to the continued Iranian non-compliance with the JCPOA. In parallel, political debate continued over the prospect of EU sanctions against Israel, although it remained uncertain whether consensus across the member states would emerge. We will come back to the specifics of some of these issues in future episodes of the podcast. In this episode, however, our focus turns to a critical, though sometimes underappreciated pillar of EU sanctions policy: enforcement. On July 24, 2025, the European Commission initiated infringement proceedings against 18 member states for failing to fully transpose Directive 2024-1226 on the definition of criminal offences and penalties for the violation of union restrictive measures into their national laws. This directive, adopted in late April 2024, represents a key milestone in the EU's efforts to enhance and harmonize criminal laws across the EU by making the violation of sanctions a similarly defined and prosecutable criminal offense in every member state. The new framework aims to ensure that EU sanctions are not only adopted uniformly, but also enforced effectively and consistently. To discuss the directive and help us navigate these complex issues, I am very pleased and honored to be joined by Ingrid Breit from the European Commission.
Ingrid, thank you so much for joining.
Hello. Hello, Jan.
Ingrid, before we discuss the directive, could you tell us a little bit about your current role at the European Commission?
Yes, of course. I am Deputy Head of Unit in DG Justice and Consumers in the European Commission, and I'm working in the unit in charge of criminal justice. So the unit covers general criminal law matters, and we develop and oversee EU criminal law policy, including the oversight of the functioning of agencies and bodies such as the EPO and Eurojust. And we are also responsible for justice-related issues concerning the Union's reaction to Russia's war of aggression against Ukraine. For example, the Special Tribunal for the Crime of Aggression, the Register of Damage for Ukraine, the establishment of the International Claims Commission, and the Freeze and Seize Task Force. We are also working hand in hand with other Commission services, typically also colleagues from DG FISMA, who are in charge of monitoring and enforcement of sanctions on behalf of the European Commission.
Yes, it's a very broad scope, and I think we'll come back to some of the agencies you mentioned, Eurojust, for instance, and the EPPO, but I think if we take a big picture approach first, to fully understand the directive, and in particular what it seeks to accomplish, could you give us a little bit of a perspective on the genesis, on how implementation and enforcement of EU sanctions work today in terms of competence? And I mean by this, who does what?
Well, Union restrictive measures, or so-called EU sanctions, are an essential tool for the promotion of the objective of the common foreign and security policy, as set out in Article 21 of the Treaty on the European Union. These objectives include safeguarding the Union's values, maintaining international peace and security, as well as consolidating and supporting democracy, the rule of law, and human rights. Decisions on the adoption or lifting of sanctions are taken in the Council of the European Union on the basis of proposals from the High Representative of the Union for Foreign Affairs and Security Policy. Currently, the Union has over 40 sanction regimes in place. Some of these implement restrictive measures by the United Nations, others are adopted autonomously by the Union. As the adoption of EU sanctions have intensified over the last decades, and notably since Russia's war of aggression against Ukraine, so too have the schemes to evade them. Practice has shown that only very few individuals or legal persons are held responsible for the violation of EU sanctions. The implementation and enforcement of EU sanctions is primarily the responsibility of member states. The competent authorities in the member states have to assess whether there has been a breach of the EU sanctions regime and to take adequate measures. Those involved in illicit practices concerning EU sanctions have profited from the fact that member states have, or at least had, very different definitions and penalties for the violation of sanctions under their administrative and/or criminal law. Some member states used broad definitions, others had more detailed provisions in place, for instance providing a list of prohibited conduct. No harmonization had taken place until the directive on sanction violations was adopted. It also appeared that in a number of member states, insufficient priority has been given to investigating and prosecuting breaches of EU sanctions.
So the legal document, the legal instrument that was adopted by the Council and the European Parliament is a directive, as you mentioned, and it's titled The Definition of Criminal Offences and Penalties for the Violation of Union Restrictive Measures. One of the questions I wanted to ask you, Ingrid, is why do we have a directive? Could this have been done with another legal instrument? And what were the options, and why was the directive the appropriate tool ultimately?
Well, the harmonization measures have indeed been adopted in the form of a directive, not a regulation. Let me first explain the difference. A regulation is a legal act that is binding in its entirety. It is directly and uniformly applicable to all member states as soon as the regulation enters into force, without needing to be transposed into national law. A directive sets binding objectives upon EU member states to achieve a certain result, but leaves them free to choose how to achieve those objectives. Once adopted at EU level, EU member states must adopt measures to incorporate the directive into national law. To transpose, national authorities must communicate these measures to the European Commission. The transposition into national law must take place by the deadline contained by the directive, which is normally 2 years. For the directive on sanction violations, it was only 1 year, given the urgency as the war is still ongoing. When a country does not transpose a directive, the Commission may initiate infringement proceedings. So why did the Commission adopt a directive and not a regulation? In accordance with the treaties, the area of freedom, security and justice is an area of shared competence between the European Union and its member states. In particular, in the area of substantive criminal law, EU competence has been limited. Article 83 TFEU, which is the main legal basis, outlines the EU's power to establish minimum rules regarding the definition of criminal offences and sanctions for specific types of serious cross-border crimes. It refers explicitly to the form of a directive.
Thank you for explaining this so clearly, Ingrid, because I think in the previous episodes of the podcast, we paid a lot of attention to the process for adopting sanctions, and I think the general question of how sanctions are made as part of the common foreign and security policy. We are now in the area of freedom, security, and justice, so we're a little bit in a different space. But in terms of the need for the directive, what was originally the problem?
What are the main issues? While EU sanctions are adopted by the Council, as I mentioned previously, their enforcement lies with EU member states. In particular, member states' competent authorities are responsible for assessing whether there has been an infringement of the relevant Council regulations and for taking adequate steps. To this end, Council regulations setting out EU sanctions systematically include a provision on penalties that require member states to adopt national rules providing for effective, proportionate and dissuasive penalties to be applied in the event of a breach of their provisions. In response to the Russian aggression against Ukraine, such provision has been strengthened by requiring member states to lay down rules on penalties, including, as appropriate, criminal penalties, applicable to infringements of the regulation. While these provisions serve as a legal basis for obliging member states to lay down penalties, including criminal penalties, neither can be used for defining the exact types and levels of criminal penalties. The limited impact of obliging member states to have criminal penalties in place without approximating criminal definitions and penalties by a directive based on Article 83 of the TFEU meant that member states also did not have a harmonized approach towards confiscation measures relative to the violation of union restrictive measures, as well as freezing, management and confiscation measures provided for in the Union acquis on asset recovery and confiscation would not apply to the violation of union restrictive measures. Even if in several member states the violation of union restrictive measures had been criminalized, differences among member states led to a fragmented approach, and penalty provisions for sanction violations differed significantly among the member states, as highlighted in a comprehensive report published by the Genocide Network in December 2021. This weakened the enforcement of EU sanctions and undermined the credibility of the Union's objectives.
How did that landscape look like from your perspective in terms of the differences, and how significant were these differences, if they were significant?
Well, as already mentioned previously, in the absence of union-level harmonization, national systems differed significantly as far as the criminalization of the violations of EU sanctions was concerned. And I may refer to the report of December 2021 by the Genocide Network on the prosecution of sanctions violations in national jurisdiction, where a comparative analysis was carried out. And it showed that in 12 member states, the violation of union restrictive measures was solely a criminal offense. In 13 member states, the violation of union restrictive measures can amount to an administrative or a criminal offense. The criteria according to which the conduct falls within one or the other regime category were usually related to its gravity, either determined in qualitative or quantitative terms, but they were different in each member state. In 2 member states, the specific offences of violation of EU sanctions only led to administrative penalties. According to the report, penalty systems differed substantially across member states. So to give you a bit more of concrete examples, as regards prison sentences, in 14 member states, the maximum length of imprisonment was between 2 and 5 years. In 8 member states, maximum sentences between 8 and 12 years were possible. The maximum fine that could be imposed for the violation of EU sanctions, either as a criminal or as an administrative offense, varied greatly across the member states, ranging from €1,200 to €500,000. Moreover, 14 member states provided for criminal liability of legal persons for the violation of union restrictive measures. In addition, 12 member states provided for administrative penalties, notably fines which may be imposed on legal persons when their employees or their management violate restrictive measures. The maximum fines for legal persons ranged from €133,000 to €37.5 million.
Yeah, that's quite a delta, 133,000 to 37.5 million. In Article 83.1 of the TFEU, there's a reference to the notion of an EU crime. Could you help us understand what this means? What is an EU crime, and what is the significance now that violating EU sanctions has been elevated to that status?
Article 83, paragraph 1 of the TFEU provides for an exhaustive list of areas of particularly serious crime with a cross-border dimension, known, as you mentioned before, Jan, EU crimes, for which the European Parliament and the Council may establish minimum rules concerning the definition of criminal offences and sanctions. Those areas of crime are, for example, terrorism, trafficking in human beings and sexual exploitation of women and children, illicit drug trafficking, illicit arms trafficking, money laundering, corruption, counterfeiting of means of payment, computer crime, and organized crime. However, the list did not allow for establishing minimum rules concerning the definition of sanctions, of offences and sanctions for the violation of restrictive measures. Under Article 83, third subparagraph, based on so-called developments in crime, the Council may adopt a decision, subject to the consent of the European Parliament, extending this list by adding other areas of crime. This decision requires unanimity in the Council. The Commission may present an initiative to trigger such a Council decision through a communication to the European Parliament and the Council and a proposal for a Council decision. And the Commission has adopted such a communication together with a proposal for a Council decision in May 2022 concerning criminal penalties for the violation of union restrictive measures.
Which I think, unless I'm mistaken, was followed by a decision of the Council that came in relatively quickly. From my perspective, at least, this shows how significant the topic, the matter has become for the EU institutions.
Yes, absolutely. To combat crime effectively, the criminal justice authorities and law enforcement authorities of EU member states need to work together. In a common European area of justice, national law enforcers and judiciaries should be able to trust and rely on each other. Action on EU level leads to minimum harmonization of criminal offences and penalties for natural and legal persons in all EU member states, and therefore to a further alignment of national law. It helps to overcome the different definitions of and heterogeneous sanctions for the violation of union restrictive measures under member states' administrative and/or criminal law, which represent an obstacle to the consistent application of the Union policy on restrictive measures. Moreover, this may also represent an obstacle for judicial cooperation as well as for the consistent action of EU agencies such as Eurojust and Europol. They may even lead to forum shopping by offenders and ultimately their impunity because they could choose to conduct their activities in the member states that provide for less severe responses to the violation of Union restrictive measures. Harmonization increases the deterrent effect of sanctions for the violation of Union restrictive measures.
And now that we understand the treaty and legal framework within which the directive was proposed and ultimately adopted, could you walk us through a little bit the process itself? What were the main steps and the main milestones in getting this proposal through the legislative process?
Against the background of the war in Ukraine and what I just explained before, and in order to address the fragmentation and strengthen the enforcement of the European Union sanctions across the member states, the European Commission took a two-step approach. First, on 25th May 2022, the Commission tabled a proposal for a Council decision on identifying the violation of Union restrictive measures as an area of crime that meets the criteria specified in Article 83, the so-called Eurocrimes, on which we talked before, and the Council decision was then adopted on 28 November 2022. Based on that decision, if I may, I refer to the exact title. It's a decision of 2022/2332. The list of EU crimes has been extended for the first time. Second, on that basis and only 4 days later, the Commission put forward on 2nd December 2022 a proposal for a directive on the definition of criminal offences and penalties for the violation of Union restrictive measures.
And then did the proposal go through the standard process, or did it follow exceptional rules given the circumstances?
The proposal went through the ordinary legislative procedure, which consists of the joint adoption of a legislative act by the European Parliament and the Council of the European Union, following a proposal from the European Commission. So negotiations started in January 2023, the Council with the European member states. A so-called general approach could be adopted under the Swedish presidency already in June 2023. A few weeks later, trilogue negotiations started between both co-legislators, meaning the Council and the European Parliament, and after only 1 year of negotiations in total, political agreement on the text of the directive was reached in December 2023 under the Spanish presidency. After further linguistic revision, the directive was then formally adopted on 24 April 2024 and 19th May 2024.
And as a result, the transposition deadline was May 20th, 2025. I was, having followed the discussions and the evolution of this proposal from the very beginning, I was very impressed by the speed at which the idea, the proposal, and the directive itself went through the various hoops, and in particular of the negotiations with the member states. So now that we have the directive adopted and it should have been transposed by May 20th, 2025, I'd like for us to pivot to the substance. What's in the directive, and how would you go about presenting its content? Because it's a technical document, of course, and for some of our listeners who are hearing about the directive for the first time, could you help us navigate through this important document?
Sure. I think Article 3 on the definition of offences is certainly the core provision of the directive. It provides for a comprehensive list of criminal offences related to the violation of EU sanctions. Such offences cover, for example, the violation of asset freeze measures, the violation of travel bans, the violation of economic and financial sectoral measures and arm embargoes, and the circumvention of EU sanctions. This offence addresses cases in which designated persons, entities, and bodies use, transfer to a third party or otherwise dispose of funds or economic resources directly or indirectly owned, held, or controlled by them in order to conceal these funds or economic resources. It also applies to cases in which false or misleading information is provided to the competent authorities in order to conceal frozen funds or economic resources. In addition, such offence also covers the failure to report assets belonging to, owned, held, or controlled by designated persons, entities, or bodies, and also includes the failure to provide the competent authorities with information on frozen funds or economic resources in breach of the relevant obligations set out in the Council regulations laying down Union restrictive measures. Finally, the list of offences covers also the breach or failure to fulfill conditions under authorizations granted by competent authorities. The directive introduces also monetary thresholds, allowing member states to distinguish between criminal and administrative offences. This provision enables member states not to criminalize criminal conduct respectively involving funds, economic resources, goods, services, activities, or transactions of a value of less than 10,000 euros. It was inserted by the Council to ensure respect for the criminal law principles of proportionality and ultima ratio. This threshold does not apply to violations of travel bans. In terms of mens rea, all criminal offences covered by the directive require intent. Serious negligence is required as a standard for culpability, at least for the criminal offence related to the violation of trade restrictions when involving arms or dual-use items. The notion of serious negligence should be interpreted in accordance with national law, taking into account relevant case law of the Court of Justice of the European Union. Lastly, let me also mention that the directive protects the delivery of humanitarian assistance or activities in support of basic human needs in line with Article 214 TFEU and international humanitarian law obligations of the European Union and its member states.
Ingrid, you mentioned the definitions, so now the common definitions of these violations, and you mentioned also the mens rea, so the mental state that's required under the directive, or that should be required under the laws of the member states implementing the directive. How does the directive go about penalties? What is the thinking and what are the requirements in the directive from the perspective of penalties?
Well, one of the key objectives of the directive is to ensure that violations of EU sanctions have similar legal consequences throughout the European Union and thus create a level playing field for natural and legal persons. As regards natural persons, the directive lays down a graduate system of minimum-maximum imprisonment penalties of 1, 3, and 5 years, in addition to the general obligation for member states to lay down effective, proportionate, and dissuasive penalties. This system is differentiated on the basis of the gravity of the criminal offence concerned and is applicable once the monetary threshold of 100,000 euros has been reached. To be noted that this threshold does not apply to violations of travel bans. In addition to imprisonment, member states must also provide for ancillary penalties, which may include fines, withdrawals of permits and authorizations, disqualification from holding a leading position within a legal person, and others. Let's turn now to the liability of legal persons and penalties for legal persons. Not only natural persons, but also legal persons are subject to EU sanctions and should be held liable for offences as defined in the directive. Legal persons can be held liable when offences covered by the directive have been committed for their benefit by any person who has a leading position within the legal person or by persons under his or her authority, in case of a lack of supervision or control by the person with a leading position. It is important to underline that the liability of a legal person should not exclude criminal proceedings against a natural person. The directive obliges member states to provide for fines as the main penalty for sanctions violations. In this context, one of the novelties introduced by the directive, compared to previous criminal law instruments, is the calculation method for setting fines at the national level. It is to be based either on a percentage of the annual worldwide turnover generated by the legal person in the business year preceding the fining decision, or the commitment of the offense. The directive provides for 1% or 5%, depending on the offense concerned, or on a fixed minimum-maximum amount ranging from 8 million euros to 40 million, depending on the gravity of the offense in question. The introduction of this alternative calculation method is consistent with the approach recently also adopted in the new directive on the protection of the environment through criminal law. Even though the Commission's proposal previously relied on an annual global turnover figure, which was considered the most effective and fair calculation method for setting fines at the national level, the alternative method based on fixed amounts considerably increases the average fine levels currently applicable in member states for sanctions violations. In addition to the fines, member states can also decide to provide for ancillary penalties applicable to legal persons in their national systems, such as exclusion from entitlement to public benefits or aid, the exclusion from access to public funding, including tender procedures, grants and concessions, disqualification from the practice of business activities, or the withdrawal of permits and authorizations, and some others as well.
And I think the directive also sets forth some new provisions regarding confiscation.
Absolutely. Another main objective of the directive is to facilitate the confiscation of assets and resources subject to EU sanctions when there is a link with a criminal activity. This objective is ensured, in particular, through the interlinkage between this directive and the new directive on asset recovery and confiscation, replacing the old directive 2014/42 EU. Compared to the old directive, this new directive on asset recovery and confiscation allows for the confiscation of assets, proceeds or instrumentalities stemming from a wider sense of crimes, including violations of union restrictive measures. In addition, the directive on the sanctions violations introduces a new confiscation regime targeting assets subject to EU sanctions, even where such assets might not be considered proceeds or instrumentalities under the Directive on Asset Recovery. However, this new confiscation regime can apply in specific cases of sanction circumvention only. This means cases in which a listed person, for example, uses, transfers to a third party or otherwise disposes of frozen assets, or provides false or misleading information on frozen assets in order to conceal these assets. In these cases, confiscation must be enabled vis-à-vis a designated natural person or a representative of a designated entity or body who has directly committed or participated in the criminal offences concerned. The new regime will apply in accordance with the provisions of the Directive on Asset Recovery and Confiscation, particularly regarding the procedural safeguards laid down therein, as well as non-standard confiscation methods, for example, value-based confiscation, third-party confiscation, or non-conviction-based confiscation.
It is quite common for sanctions cases to touch on not just one member state, but several member states. And I was wondering to what extent does the directive address or consider the question of cooperation in the context of implementation and enforcement of EU sanctions?
The directive introduces two specific provisions concerning internal and external cooperation in view of the overall objective of strengthening the enforcement of EU sanctions. As regards internal cooperation, Article 15 of the directive lays down an obligation for member states to designate from among their competent authorities a dedicated unit or body to ensure coordination and cooperation between law enforcement authorities and authorities in charge of implementing EU sanctions. It also further specifies the tasks of such a unit, which include promoting common priorities and an understanding of the relationship between criminal and administrative enforcement, exchanging information for strategic purposes, and ensuring consultation in individual investigations. In addition, Article 16 of the directive provides for specific rules on cooperation between member states, competent authorities, the Commission, and other relevant EU institutions, bodies, offices, and agencies, such as Eurojust, Europol, and the European Public Prosecutor's Office, the EPPO, which we mentioned already at the beginning, whose respective roles would come into play within the current. The same provision also allocates a specific role to the Commission, which could provide non-operational assistance where appropriate, including via the setting up of a network of experts and practitioners to share best practices and provide assistance to the competent national authorities. And indeed, the Commission is already playing a relevant coordination role in the field of sanction enforcement and implementation, notably in the context of the Task Force Freeze and Seize, which has been set up in the aftermath of Russia's war of aggression against Ukraine, as well as in other relevant expert groups already established in the field of union restrictive measures. In addition, the directive also refers to the importance of ensuring international cooperation in this field, which should take place with full respect of fundamental rights and international law. Such cooperation is ongoing, especially through regular exchanges between the Commission, G7 partners, Ukraine, and other relevant third countries.
Is there a particular philosophy in terms of enforcement policy that is enshrined in this directive, or is that up to the member states ultimately when they look at particular cases?
Well, the objectives of the directives are, on the one hand, to approximate the definitions of criminal offences and to ensure effective, dissuasive and proportionate penalties, to lay down the types and levels for criminal offences and penalties, and thus to create a level playing field within the EU for sanctions enforcement. It's also to foster cross-border investigations and prosecutions and to improve the operational effectiveness of national enforcement chains to foster investigations, prosecutions and sanctioning, and thus enhance the effective enforcement of EU sanctions and punish those which violate them. At the same time, these rules contribute also to legal clarity and certainty and will hopefully also help to prevent sanctions violations by individuals or by companies.
Looking at this time between the entry into force and the end of the transposition period, from your perspective, has the directive already prompted meaningful reform, and what has been the impact so far, if you're able to share some thoughts on that?
As mentioned before, the directive entered into force on the 19th May 2024 and had to be transposed into national law within 12 months, which is a very short period in comparison to similar criminal law instruments. Some member states have created working groups or task forces for the implementation of this directive, and legal reforms have been initiated in a number of member states. Some member states have also created, in the meantime, specialized units as required by the directive. So what is the current state of play? So far, the Commission has received notifications on national transposition measures from a number of member states. However, the measures from several member states are still outstanding. In addition, some notifications only contain partial transposition measures. We will look now into detail, and this means that we will check whether member states have taken the required transposition measures and whether those measures are also in line with the requirements of the directive. Where necessary, the Commission will follow up with infringement proceedings against those member states which have not yet transposed or where the transposition measures are not conform.
Looking ahead now, Ingrid, What would you say are the main challenges or key topics when it comes to implementing and carrying out the objectives set by the directive?
Well, we will continue to support member states with the transposition of the directive. As I just said, I mean, not all member states have yet fully transposed. So one of the key challenges is certainly to have the directive as quickly as possible transposed by all member states. We will also continue the work of the Freeze and Seize Task Force, which has its main aim to improve the enforcement of EU sanctions, including by contributing to the strengthening of the fight against their violations. The task force played an important role in coordinating and monitoring the freezing of Russian private assets in the European Union, from 8 billion euros of frozen Russian assets in March 2022 to more than 28 billion by May 2025. Due to its cross-disciplinary approach, the task force helped also design new enforcement tools, such as the voluntary self-disclosure of sanction violations, which was included in the 13th package of sanctions, or the directive. We will assist member states in developing national strategies to address sanction violations, notably by using the task force as a hub to share patterns or best practices. Also, the training of judicial authorities, lawyers, and law practitioners more broadly will be important, as violation of sanctions is a relatively new area with which not everybody is familiar. Finally, we will explore how the relevant EU agencies and bodies like Europol, Eurojust, and the EPPO could step up their fight and their role in combating sanctions violations.
Perhaps just following up on the EPPO, so the European Public Prosecutor's Office. I think there's been some interest in understanding what the role of the EPPO is today in the field of EU sanctions, if there is any role, and what that role could become in the future. I think the directive alludes to the EPPO in a few instances, but from an institutional or I would say, enforcement architecture perspective, what is the competence of the EPPO today, and how could this evolve in the future?
Well, let me first briefly explain the EPPO. As you said, it's the European Public Prosecutor's Office, which is an independent public prosecution office of the European Union. It seeks to protect the budget of the European Union by investigating and bringing to judgment crimes against the financial interests of the European Union. The EPPO undertakes investigations, carries out acts of prosecution, and exercises the functions of prosecutor in the competent courts of the participating member states. The EPPO has been operational since 4 years and has already delivered excellent results. The possibility of extending the competence of the EPPO to violations of union restrictive measures has been debated over the past years. In terms of procedure, pursuant to Article 86, paragraph 4 of the TFEU, an extension of the EPPO's competence to any other area of serious crime having a cross-border dimension requires an unanimous decision of the European Council. This decision is to be taken after obtaining the consent of the European Parliament and after consulting the Commission. Furthermore, once the EPPO's competence has been extended, the Council would need to adopt a revision of the EPPO regulation so as to give effect to the new competence for the EPPO and introduce any adjustment that may be required for the EPPO to exercise its investigation and prosecution powers on the new criminal offences. This decision of the Council also needs to be taken unanimously, which in this case means unanimity only of the member states participating in enhanced cooperation. This means all 27 except for Denmark, Hungary, and Ireland. The consent of the European Parliament will be needed as well. If this avenue is pursued, the necessary financial, technical, and human resources implications for the EPPO will have to be assessed as well. From a substantive point of view, there may be a case for extending the EPPO's competence to the criminal offences harmonized by the new directive. First, and as outlined before, union restrictive measures are an essential tool by which to promote the CFSP objectives. Therefore, as with the EU budget, their effective enforcement could be considered as an interest pertaining to the union itself, thus justifying criminal enforcement at the EU level. In addition, the violation of EU sanctions is an area of crime that would be in line with the EPPO's current mandate, as it often requires cross-border investigations into complex economic and financial crimes. This also implies that, at least to a certain extent, the EPPO staff would already be equipped with the necessary knowledge and expertise in investigating and prosecuting such criminal offences. Another argument in favor of extending the EPPO's competence is that the EPPO is already competent to handle certain cases of violation of union restrictive measures, as long as they are inextricably linked to criminal offences affecting the union's financial interests. This may be the case, for instance, if customs fraud involves the import into the territory of a member state of certain goods whose import, export, transit or transport is prohibited under EU sanctions. In such cases, the EPPO could exercise its competence in accordance with Article 25, paragraph 3 of the EPPO regulation. As outlined before, the new directive acknowledges this possible role for the EPPO in its Article 16. At least 10 member states have already expressed their support for a limited extension of the EPPO's competence to the violation of EU sanctions. But in view of the procedure laid down in Article 86, paragraph 4 TFEU, the agreement of all member states on this initiative is of essence. We from the Commission are open to continue its assessment of the feasibility of extending the EPPO's competence to violations of EU sanctions, most notably within the framework of the ongoing evaluation of the EPPO regulation as required by Article 119 of the EPPO regulation and due by June next year. Such an extension of material competence is obviously and primarily a political decision, as it involves a further transfer of national competences in the area of criminal prosecution to an EU body.
Ingrid, I wanted to take a moment to thank you again for your time and for explaining the work of the Commission in preparing, in proposing and working with the institutions in the member states in the implementation of this very important document, which I think is fair to say already has and will have a significant impact on the enforcement framework within the European Union. I thought what was interesting is that some of the impact and influence that this text has had was obviously quite immediate, quite quickly prompted discussions, obviously, in all parts of the Union and in the member states on how to tackle the transposition. But I'll be very curious also in following the longer term, I think, consequences of this text. I think you mentioned that there may be some scenarios, of course, if some member states do not transpose the text under what is foreseen by the treaty, but I think it will continue to have a significant role in shaping a common culture for EU sanctions implementation, compliance, and enforcement. So thank you very much for everything that you and the Commission team have been doing and for sharing this with us and our listeners.
Thank you very much, Jan, also for giving me this opportunity. And I would like to take this occasion also to thank my colleagues in my unit, notably Peter Jonke, Head of Unit and Acting Director, Fabio Giuffrida, who is the team leader of the Freeze and Seize Task Force, and Lucia Zolli, who is Policy Officer in charge of the negotiations of the directive, and all other Commission colleagues working on sanctions and their enforcement. I would also like to add a disclaimer. The views expressed in this podcast are solely those of the author, so myself, and are not an expression of the views of the institutions with which I am affiliated.
This concludes this month's episode. If you've enjoyed the show, please follow the podcast, leave a review, and share it with colleagues or peers interested in EU sanctions law and policy. Don't forget to subscribe to the LinkedIn newsletter if you haven't already for additional materials. Thank you again for listening, and tune in soon for the next episode.